Hi, everyone. Good afternoon. It's a fantastic thing to be here welcoming a guest from a warmer climate on the coldest day we've had in Winnipeg yet this year, so welcome. Maybe this year, this season. I don't think even in December we had this cold. I'm Lorna Turnbull, and I'm a member of the Distinguished Visitors Committee, and I have the privilege of introducing our guest today. We have with us Anne Fleming from Georgetown University, and as you can see from the slides, she's going to talk to us about unconscionability and the law of the poor. Now, this is one slice of the kind of work that she does, and there's a whole range of other interesting things that she does, and I might touch briefly on one of them just because it's so interesting and it has a connection here in Winnipeg. But let me first tell you a little bit about who Anne is. So, as I said, she's at Georgetown. She teaches and researches in contract and commercial law, consumer finance, and American legal history, with a focus on the relationship between law and poverty. She's also the author of a book which has won 2 prizes. The book is called The City of Debtors, A Century of Fringe Finance, and it came out with Harvard University Press in 2018. And in 2019, she won both the Ralph Gomery Book Prize for the Business History Conference and the American College of Consumer Financial Services Lawyers Best Book Award. So this is someone who knows what she's talking about, and I think it's going to be really interesting to hear from her. As with many of our colleagues south of the border, she has a curriculum vitae that has her having gone to leading Ivy League schools and ranked very highly, thank you very much, at Harvard and Yale, and I feel like I'm missing one, Pennsylvania. And she also clerked for the U.S. District Court of the Southern District of New York and the U.S. Court of Appeals for the Third Circuit. As well, she's practiced law as a staff attorney for South Brooklyn Legal Services, representing low-income homeowners facing foreclosure. As well as teaching at Georgetown, she also taught at Harvard Law School. And the little link with Winnipeg that I wanted to mention is she's been busy in the press last year talking about payday loans in the American context. But here in Manitoba, the Public Interest Law Centre represented clients of Winnipeg Harvest and a group of other folks living in low income before the Public Utilities Board, who was reviewing the rates of payday loans in Manitoba. And as a result of the intervention of lawyers, hence the link between law and poverty, Manitoba has the lowest payday loan rate in the country, about 20% below the next lowest. So these are really important things to think about as we think about the quality of life of folks living in our communities and needing to make use of those. So without further ado, I can tell you that I'm handing you over into the hands of someone who's going to have a lot of interesting stuff to tell us about unconscionability, the law of the poor, and the links between law and poverty. So please join me in welcoming Anne Fleming.
Thank you. So good afternoon. It's really a pleasure to be here. I was a little concerned about the cold, but it turns out that you don't actually have to spend that much time outside in Winnipeg, or at least I have not, so it's very warm inside. I also wanted to thank the Distinguished Visitors Committee, Professor Maharaj, Professor Turnbull, for inviting me here today, and also Professor Virginia Torrey and Professor Amar Kode, who welcomed me to a legal history seminar this morning to talk about some of my other work on the history of bankruptcy law. So I work on the legal history of consumer credit regulation and bankruptcy, and I have a focus on the relationship between low-income households and the law, and sort of the impact of legal regimes on poverty. So one strand of my research looks at the history of small-sum lending to the poor in the United States over the course of the 20th century. It looks at the growth and regulation of what today many people refer to as fringe finance. So in America, that would include payday lenders, pawn shops, and rent-to-own stores. Now, until quite recently, legal historians had not shown a lot of interest in the regulation of consumer credit. Constitutional law, civil rights, these had developed a much larger and deeper literature. And the handful of scholars that had written on consumer credit had focused their work on federal regulation and federal programs. So they had, for example, looked at the creation of federal home mortgage insurance in the US during the Great Depression, on federal mandatory disclosure laws, truth in lending laws in the 1960s. But in the US, we have a divided system of government, which we call federalism. So some regulation happens at the national or federal level, but a lot of regulation, particularly economic regulation, happens at the state and local level. So over the course of the 20th century, a lot of the developments at the federal level were the ones that really got attention in the press, among everyday people. But for most of the 20th century in the United States, the federal government really played second fiddle to the states when it came to regulating debtor-creditor, everyday borrowing and lending relationships. So even as our federal government's reach was expanding over the course of the 20th century, even as federal regulation spread into more areas of economic life, the states retained primary control over this particular domain of economic activity. So if we want to understand consumer credit's legal past, we have to look below what's happening at the federal level and look at what's happening in the states. And that's what my work aims to do and what I'm going to be talking about today. So what I've found in my research is that the story in the states looks different than the story at the federal level. So at the federal level, you get two kind of big bangs of regulation. First during the Great Depression in the 1930s, and then later during the Great Society, Lyndon Johnson's presidency in the 1960s. But if we look at the states, instead of these two kind of big moments, you get kind of a steady drumbeat of regulation. And instead of statutes that emphasize procedural protections like disclosure or non-discrimination rules, in the states you actually get rules that regulate the substance of loan terms and that try to limit the reach of creditors in pursuing debtors for unpaid debts. And these state rules were the focus of my first book, City of Debtors, which looks at the rise in regulation of small dollar lending. Which is really a story of state-level regulation. Federal government only comes in at the very end of the story and still has kind of a limited role to play in regulating small dollar credit. So what I'm going to be talking about today is one chapter in this state-level history, and it's a chapter about the role of the doctrine of unconscionability and unconscionability litigation in policing consumer credit to the poor in the United States. So in the US, the doctrine of unconscionability provides a defense to enforcement of a contract. So if a court finds that either the entire contract or a particular contract term is unconscionable, then the court can refuse to enforce the contract or that particular contract term. And most American lawyers learn about the doctrine of unconscionability in the basic first-year contracts class. So they know that in the mid to late 1960s in the US, there was this kind of burst of unconscionability litigation that involved poor consumers asserting the defense of unconscionability. And many American lawyers learn about the doctrine of unconscionability by reading those cases that are now over 50 years old from the mid to late 1960s. And the most famous case in the US is called Williams v. Walker Thomas Furniture Company. So here you see a slide of the caption of the case from when it reached the highest court in the District of Columbia, which at the time was the DC Circuit. So the Williams case appears in almost every first-year contracts casebook in the United States. And the reason it does is because it was one of the very first cases to really delve into the doctrine of unconscionability. It was one of the first cases to explain what the doctrine was and also to describe how a court should go about evaluating an unconscionability defense. And in the decision, which was written by Judge Skelly Wright, who I will show you in a minute, he wrote in the Williams decision that unconscionability basically has two elements. So unconscionability has generally been recognized to include both a procedural defect in the bargaining process, so what he referred to as an absence of meaningful choice on the part of one party, the party asserting the defense, as well as a substantive flaw in the terms of the deal, what he referred to as terms that unreasonably favor the other party in the transaction. So Judge Wright in Williams was the first to lay out these kind of two-part tests for unconscionability. The case became famous in part because so many other courts cite this decision as kind of the touchstone for what the elements are to prove an unconscionability claim. It's also a famous case because it inspired other borrowers and lawyers in the United States to assert unconscionability as a defense to enforcement of other consumer contracts in litigation that played out in the 1960s and 1970s. So almost every American lawyer learns about the doctrine of unconscionability in the first-year contracts class, and many of them learn about it by reading the Williams case. But what most of these lawyers don't learn is why unconscionability kind of suddenly appears on the scene in the 1960s, and also why you see this drop-off in the number of unconscionability cases from the mid-1970s onward, particularly unconscionability cases involving consumers like Ms. Williams, poor consumers who are asserting the defense to enforcement. So there is an explanation for this pattern in the existing scholarly literature. And the explanation goes something like this. So this unconscionability revival in the 1960s was really the work of a generation of activist judges. Judges like Skelly Wright, who decided that they were going to rewrite consumer contracts according to the judge's own sense of justice. But these judges ended up hurting the very people they were trying to help. So unconscionability became understood as not a very helpful doctrine. Unconscionability review faded away, and judicial review of contracts for unconscionability was supplanted by other types of policing, specifically rules governing mandatory disclosure and rules preventing discrimination based on race, gender, and other protected categories. So that's one story, and that's the story that I was kind of working against in this research that I did into the Williams case. So my research uncovered a different narrative. So instead of there being really a conflict between what judges were trying to do and what the legislature ultimately accomplished, what I see is really a convergence between the legislature and the courts. So what I found was that it was the legislature that laid the groundwork for the flowering of unconscionability in the mid-1960s, and that it was also legislative activity that accounts for the decline in the number of unconscionability cases involving poor consumers in the mid-1970s onward. So as I said, my story centers on the Williams case. So the borrower in the case was Ora Lee Williams, and she had bought some household furniture from the Walker Thomas Furniture Store, which was just a local furniture store in Washington, D.C., and she made these purchases over the course of 5 years, between 1957 and 1962. Now, she didn't actually go to the Walker Thomas store. Walker Thomas employed a team of door-to-door salesmen that went to her home, which was several miles away from the Walker Thomas store. But this is a picture of the Walker Thomas storefront, which is right in downtown Washington, D.C. So Ms. Williams was a poor mother of 7 children, and she had very limited income. So she lived on a couple $100s that she received from the government in the form of public assistance. But over the course of this 5-year period, she signed over a dozen separate contracts with the Walker Thomas Furniture Company. So this is a picture of one of the contracts she signed, obviously not actual size. The actual contract was pretty small. It was about 6 inches, according to the court record. And over this period of time, every time she made a purchase of household goods, she signed a new contract. And she was buying things like pot holders, draperies, rugs, toys for her kids. And as of April 1962, nearing the end of this period, she only owed the store about $164. She had paid them over the course of 5 years over $1,000. But then she buys a stereo. So she buys a stereo for $500, and shortly after she makes this purchase, she defaults. And then after she defaults, Walker Thomas claims the right, under the terms of these sales contracts, claims the right to repossess not just the stereo, but everything that Williams had purchased over this 5-year period. And the legal basis for this claim was buried in the fine print of this contract. So here I've actually typed out the text of the contract. It's still quite small, but a little bit bigger than this, which is illegible. So this is the entirety of the text of the contract. And although you probably can't see it that well, there's this little line in red about 3/4 of the way down the page. And that was the basis for Walker Thomas's claim that they could repossess all the stuff she had bought over 5 years. The key language says, all payments made by the customer will be credited pro rata, and that title to any individual item that was purchased would not actually transfer to Ms. Williams, that Walker Thomas would retain ownership of the goods up until she had paid off the good in full. So the effect of this transaction structure was that Ms. Williams did not actually acquire title, did not own any individual item she purchased until she had paid off all of the items in full. So every time she made a payment, 50 cents of the payment would be credited to one item, 50 cents would be credited to another item. So all the payments were spread out over all the goods so that no individual good was ever actually fully paid off. So after Williams defaults, Walker Thomas files a complaint in the local DC court, and the complaint is a complaint in replevin, and it says, we own all of the stuff Ms. Williams purchased. Please, Marshal, go seize all of this stuff. So this is the complaint, and the complaint, which is a little too small to read, but has just a laundry list of everything she had purchased over the course of 5 years: pot holders, drapes, rugs, household items. And so that could have been the end of it. And in fact, I think for most Walker Thomas customers, that would have been the end of it. Walker Thomas files the complaint, the marshals go seize whichever of these items they can find, she loses her stuff, Walker Thomas gets it back, end of story. That's not what happened in this case. So in this case, Ms. Williams receives free legal assistance from this guy. So Pierre Dostert, I think is how you pronounce his last name, was a recent law school graduate who was working in an office run by the Bar Association of the District of Columbia, basically offering free legal assistance to people who could not afford a lawyer in the local DC court. So he takes the case, and he decides to challenge Walker Thomas's right to seize all of Ms. Williams' purchases. He forces the case to go to trial. At trial, he puts Ms. Williams on the stand, but he loses. And in fact, he loses at trial. He appeals to the Intermediate Appellate Court. He loses there too. And the courts basically say, the contract says Walker Thomas can do this. We don't think that this is really good business practice, but there's nothing we can do. There's no legal tool in our arsenal that we can deploy to find in favor of Ms. Williams. But her lawyer keeps appealing. So he appeals from the intermediate DC court all the way up to what at that time was the highest court in DC, which was the DC Circuit Court of Appeals. And the DC Circuit agrees to hear the case. It was discretionary whether they would review the decision or not. They grant the appeal, and the case is heard before a 3-judge panel of Judge Wright, Judge David Bazelon, and Judge Donahere. And so this is Skelly Wright. In 1965, Skelly Wright writes the majority opinion in Williams, And he says in the opinion, Mrs. Williams' contract is potentially unconscionable and therefore potentially unenforceable. And so the court remands the case back to the trial court for further proceedings. They say the trial court didn't seem to understand that they could review this contract for unconscionability. We're sending it back so they can make factual findings relevant to the unconscionability defense. So since then, the Williams case, because it's so high profile, has elicited an outpouring of scholarship. So many people have written about this case, have criticized or praised Judge Wright's decision. But what I found is nobody had actually delved back into the original litigation records. So the contract I showed you, for example, the complaint, right? Nobody had unearthed these things to try to figure out what was actually going on in this case. So that's where I started digging to try to piece together the backstory to the Williams case. And what I found is that it was the legislative enactment of the Uniform Commercial Code for the District of Columbia that actually laid the groundwork for the Williams decision. So the Williams decision then catalyzed a process of legislative change because it raised public consciousness of the issues going on in this particular marketplace. So the Williams litigation made lawyers, lawmakers in DC aware that these types of practices were going on, that Walker Thomas was including these types of terms in their contract, and it fueled a drive for statutory reform. So local lawyers, activists in DC eventually proposed legislation that's adopted by the legislature that includes a set of bright line rules. And those bright line rules, which govern contracts like the Walker Thomas contract, say pro rata allocation of payments should not be allowed. So in other words, the legislature in DC did not overrule the courts, right? They didn't view the Williams decision as the work of liberal activist judges. The legislature, in fact, seems to have been on the same page as Judge Wright in his view of the Williams contract. And in fact, in the wake of the Williams decision, codified his view that the Williams contract was fundamentally unfair and should not be enforceable. So I think in addition to revising our kind of conventional understanding about unconscionability litigation in the 1960s, these findings have some implications also for how we think about the relationship between courts and legislatures in policing consumer contracts. So first, I'm going to lay out my conclusions and then kind of delve back into the record a little bit. So first, I think this suggests a different model for how we should think about, first of all, how regulation develops, and then also how we should allocate responsibility between different lawmaking institutions. So a number of scholars have written about the problem of how you police the fine print or the boilerplate in consumer contracts. And they have framed this as a problem of institutional choice. So should the market, should the courts, or should the legislature supply the terms of these contracts and regulate the terms? But most of this work is thinking about this question of institutional choice in kind of a static way at a particular moment in time. It's not been historical and has not viewed these institutions as interacting with one another over a period of time. And so what my research shows is that they do, in fact, interact, and that they kind of engage in a dialogue that can yield a new regulatory framework over time. So if we want to think about institutional choice, if we want to think about the problem of fine print in contracts and how it should be policed and regulated, we should really think in terms of a process rather than thinking about selecting a particular institution to carry the load and do the work of regulation. I think second, the other takeaway from this is that it suggests a different way of conceptualizing the role of courts in legal change and how we evaluate whether litigation was successful. So rather than just tallying wins and losses in courts, we can also think about the success of a litigation-based law reform campaign by looking at what's happening outside the courts. So in the Williams case, for example, the case at best ended in a tie. So I'll tell you, when the case was remanded, the trial court never decided whether this contract was unconscionable. Williams and Walker Thomas agreed to settle the case. Williams got a couple $100. Walker Thomas kept her stuff. And if we stopped there, it seems like a tie. But that's actually not the full story. So as my research shows, the litigation here actually served a broader purpose. It served to raise the salience of this particular issue of practices in the retail installment sales market, and drew public attention to what was happening on the ground. And it then fueled a debate that took place in the political branches outside the judicial system, and that debate then led to the enactment of statutory reforms. So now I'm going to lay out my evidence for this argument in a little bit more detail, and then I'm going to end with a very quick overview of what's going on now in this retail space. So let me start with the rise of unconscionability. What sparks the revival of the common law doctrine of unconscionability that sort of appears in the Williams case in 1965? And why does this happen in 1965 and not much earlier? So my argument is that common law unconscionability and the rise of common law unconscionability had everything to do with legislation. It had to do with the legislative adoption of the UCC for the District of Columbia. So the UCC, the Uniform Commercial Code, includes an article on sale of goods, and the Article 2 on sale of goods includes a provision, Section 302, that specifically mentions unconscionability. So this is the text of the statute that was ultimately adopted in DC. And it says that if the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract. Now, to be clear, the Williams case was not decided under the UCC. And this was because the UCC was not in effect in the District of Columbia at the time that Williams was entering into these transactions with Walker Thomas. The UCC was not actually adopted for the District of Columbia until December 1963, after Williams had already lost her possessions, after her case was making its way through the DC court system. And so in the Williams decision, Judge Wright couldn't apply directly the law of sales from the UCC to the Williams transaction. Instead, what he did was he said unconscionability is actually part of the common law of the District of Columbia. And I argue that the timing of this rediscovery of unconscionability had everything to do with statute, with the UCC. So unconscionability and unconscionability as a way to protect Ms. Williams was not on the radar of anybody involved in the Williams case until 1963, until Congress adopts the UCC for the District of Columbia. So before World War II, unconscionability was an obscure doctrine in American contract law. So the doctrine dated back to the 17th century English Court of Chancery decisions in cases involving the disposition of family property. And so even though there was this word and concept of unconscionability, it was basically dormant in the United States. It was not recognized as a valid defense to enforcement of a contract. And so when lawyers like Mrs. Williams' lawyer were confronted with contract terms that seemed procedurally and substantively unfair, they had to find other ways to challenge them. So they would challenge them using other doctrines like mistake or duress, or they would try to interpret the contract in sort of creative ways to get the relief that they wanted. And we, in fact, can see exactly when the discovery or rediscovery of unconscionability took place in the Williams litigation record. So the record shows Ms. Williams did not raise unconscionability as a defense at trial, and she didn't raise it as a defense in the Intermediate Court of Appeals. She actually asserts the defense very weakly for the first time when the case reaches the highest court, when it reaches the DC Court of Appeals. And she raises it then largely because of lucky timing. So it just so happens that the UCC becomes effective for the District of Columbia, or I should say was adopted for the District of Columbia, right as Williams was submitting a request to review to the DC Circuit. And so Williams, in her request for review, raises the UCC and sort of draws the court's attention to this new UCC section on unconscionable contracts. So these are some segments from the petition for review when Williams' attorney was seeking to get the DC Circuit to review the Court of Appeals decision. And you'll notice early on in the petition, she says, the major issues in this case, court, are lack of meeting of the minds, and the contracts were against public policy, right? And then very late in the petition for review, right, she says there are 3 questions presented. Third question presented, may a court disregard the UCC, which does not become effective until 1965, even if it finds the contracts and contract of Walker-Thomas in violation of good faith and the unconscionable contract clause in section 302, right? So this is kind of an aside in the petition for review. It's not clear at this point that unconscionability is going to be a significant issue in the case at all. And in fact, why would it? The UCC did not apply to these transactions. But after Williams raises this in the petition for review, very quickly the case suddenly becomes all about unconscionability. So the DC Circuit not only grants the petition for review, it takes an unusual step, which it appoints an amicus to provide a brief to the court. The request for, or the appointment of the amicus does not say what the amicus brief is supposed to talk about. And so the amicus decides to focus on unconscionability. And in fact, the amicus brief is almost entirely about the doctrine of unconscionability and how it could be applied to this case. So it's as a result of this chain of events that really results from lucky timing that at the very 11th hour of this litigation, suddenly unconscionability becomes not only an issue, but the major issue in the Williams case. And in fact, Judge Wright ends up relying entirely on unconscionability in his decision to reverse and remand the case to the trial court. And since Williams was one of the first decisions in the country to apply the doctrine of unconscionability, courts and scholars have scrutinized Judge Wright's language in the case and his reasoning. And a number have particularly criticized the focus of the court and of Judge Wright on the particular characteristics of this borrower, Mrs. Williams. So in the decision, he talks about her lack of education, he talks about her inability to understand the contract, and they have viewed Wright's treatment of her as essentially paternalistic. But what I discovered in going through Judge Wright's papers and looking at the sort of early drafts of the Williams decision was that that was not his original focus. So in the early drafts, he really focused on Walker-Thomas, and he focused on Walker-Thomas's methods of doing business with poor borrowers in DC. And he was not so interested in Williams' individual knowledge or capacity to understand this contract. And in particular, what Judge Wright stressed in these early drafts was his concern that repossession was part of the Walker-Thomas's business model. So he suggested that perhaps the company deliberately enticed a customer to purchase a big ticket item right before they had nearly repaid all of their debts to Walker-Thomas so that the customer would default and then Walker-Thomas would be able to repossess everything the customer had previously purchased and then resell those same goods to the next customer. But as we know, that's actually not the decision Judge Wright ends up publishing. So after consulting with the other members of the panel, with Judge Bazelon in particular, and learning of Judge Donahare's plan to submit a dissent, Judge Wright shifts the focus of the opinion. So the final opinion, the one that students read in first-year contracts today, highlights the unique problems in the interface between this particular borrower and lender, rather than looking at kind of the systemic business practices of Walker-Thomas and the larger concerns that Walker-Thomas was engaged in unfair methods of dealing with its customers. So even though Wright ends up in some ways kind of narrowing the opinion to focus on the particular parties before the court rather than this larger systemic issue, Judge Wright was still pretty hopeful about the Williams decision. So in a letter that he wrote in 1967, 2 years after Walker-Thomas, after the Walker-Thomas decision came out, he described Williams and the doctrine of unconscionability more broadly as part of what he called a growing area of the law of the poor. And he said he thought that the American Law Report's entry on unconscionability would be very helpful to people who were working in this field of the law of the poor. And in fact, in some ways, he was right. So there is this brief burst of unconscionability litigation in the mid to late 1960s. And interest in the Williams case was almost immediate from people who are working in this field. So also in Judge Wright's papers, I found a letter from an organizer of a conference on the topic of consumer credit and the poor that was going to be held at the University of Chicago in November 1965. And the organizer of that conference wrote to Judge Wright. And she said, "We are extremely interested in the decision of your court in Williams v. Walker Thomas Furniture, decided August 11th, 1965, and request a copy for purposes of this conference that they were having." And then, in fact, maybe as a result of this conference or just general awareness of the decision, borrowers in other parts of the country, specifically New York and New Jersey, asserted unconscionability as a defense of their installment sales contracts. So you get decisions like Jones v. Star Credit, Frosty Fresh Corporation versus Reynoso, which also appear in many contracts casebooks, applying the doctrine of unconscionability to challenge other credit sales of household goods. But then you also see, after this burst of activity, that unconscionability does not generate as many reported decisions after that. The number of cases involving consumers like Orally Williams really drops off. And so that was my next question. What leads to this kind of decline of unconscionability just as things seem like they were starting to get going? Why didn't the doctrine have more staying power? And was Judge Wright incorrect? Was this not, in fact, a very helpful doctrine for poor consumers? So my argument is that the Williams case did, in fact, matter to poor consumers, particularly in Washington, D.C. And in fact, it helped change the rules that governed their contracts with installment sellers. But this didn't play out the way that Judge Wright probably thought it was going to. So as I said, for Mrs. Williams, the case ends when it settles after it's remanded. Trial judge never actually says her contract is unconscionable. Walker Thomas keeps her stuff. She gets some money. But that's not actually where the impact of the litigation or the major impact of the litigation landed. So this litigation also kind of sounded an alarm in the DC legal community. It alerts DC lawmakers, activists, lawyers in DC that there's a major problem in how businesses are entering into these types of contracts with poor borrowers in the district. And this is a recurring problem, not just a problem for Ms. Williams, but a problem for borrowers like Ms. Williams across the city, and that it needs a more permanent legislative fix. So after the initial appeal in Williams, an ad hoc committee was formed of concerned local lawyers and activists, and they set about drafting consumer credit legislation. So here, this is a letter that was submitted to the American Bar Journal in response to an article that was written by Williams' lawyer describing what he did in the case and how great it was. And the author of the letter is one of the members of this ad hoc committee. And what he basically says is, Williams was great. Williams is helpful to poor people, but it's not enough. He says case law is not sufficient protection. We need a statutory fix, and in fact, we have proposed to Congress a statute that would make sure that a future Ms. Williams does not need to rely on unconscionability. We've proposed a bright line rule to help her. And in fact, references to the Williams case, to the Orally Williams situation, recur in the legislative record when Congress was debating this legislation for the District of Columbia. And ultimately, Congress in 1971 actually adopts a Retail Installment Sales Act that applies to contracts between lenders like Walker Thomas and borrowers like Ms. Williams. And these installment sales contract rules include a provision that explicitly bans the term at issue in the Williams case. So it says payments received by the seller are deemed for the purposes of determining the amount of the debt secured by various security interests to have been made first applied to payments of debt arising from the sales first made. So in other words, when Walker Thomas receives payments from its customers, it has to apply them in full to paying off the oldest items purchased. Those items then become the property of the borrower, the customer, so there would not be an opportunity to repossess everything that was purchased over a 5-year period. So what we see in Washington is that by the early 1970s, the regulation of Walker Thomas type contracts, of these contracts for credit sales to poor customers, aren't really being regulated by the common law of contracts, or aren't solely being regulated by the common law of contracts. They've really been carved out and put under legislative oversight. So there's now a statutory scheme that determines what terms can be included in the Walker Thomas contract and what terms are not. So a future Orally E. Williams would not ever have to raise unconscionability as a defense, right? Or if she did, it would be to challenge some term of the contract that was not regulated by the Installment Sales Act. But if Walker Thomas retained the pro rata allocation of payments provision, you don't have to assert unconscionability, which is a very fact-specific and sort of labor-intensive defense for a lawyer to prove. You just point to the statute that says that term is not allowed. Now, of course, this brings me to where we are today. Commercial practices did not stand still after this law was adopted. So Walker Thomas Furniture itself and stores like Walker Thomas Furniture eventually do go out of business in DC. And instead, what we get is the rent-to-own business. So today, the rent-to-own industry, which includes national chains like Rent-A-Center, provides a service similar to the one that Walker Thomas once offered. So a modern-day Mrs. Williams would not probably go to an installment seller. They would go to a rent-to-own store rather than buying on installment. But rent-to-own offers a slightly different product than Walker Thomas did. So rather than selling goods on credit, rent-to-own stores purport to lease or rent furniture and other consumer goods to their customers on a weekly or monthly payment basis. So the rent-to-own deal functionally is essentially the same as what the deal was between Walker Thomas and Ms. Williams, but legally it is in fact distinct. So in most states, including the District of Columbia, rent-to-own contracts are not treated as installment sales, and as a result, they are not covered by existing consumer credit legislation. So for example, this 1971 law that has been in effect in Washington, D.C. does not cover rent-to-own transactions. And so it does not apply to the sale or lease of furniture by Rent-A-Center. So what should we take from that, right? That business practices changed and kind of made this legislative fix ineffective. So as I said at the beginning, I think at minimum this story suggests we need to rewrite the conventional narrative about the doctrine of unconscionability. So that conventional narrative stresses the dangers of the doctrine of unconscionability, that judicial review for unconscionability really ultimately hurts poor people, it backfires, it harms the people that it's aiming to help when judges recognize unconscionability claims and refuse to enforce contracts as written. That conventional narrative basically says it's better to allow the market to police consumer contracts or the legislature. But I think the conventional story ends too soon and focuses too narrowly on just the Williams litigation itself. So what my research shows is that the Williams litigation was really just one step in a larger process, and it was a process that both began and ended in the legislature. And it was ultimately the legislature, not the courts, that took decisive action on this question of how to police lending to the poor in Washington, D.C. So here we see a new regulatory regime governing the boilerplate terms of consumer contracts emerges over time, and it's through this decade-long kind of institutional dialogue between the courts and the legislature. Now, to my last point, it's true. This legislative solution was temporary. right? Lenders figured out ways to avoid these new regulations by recasting their transactions as renting to own goods rather than selling goods on credit. And I think this is, in fact, probably the norm. Anytime you have a bright line legislative rule to some sort of consumer contract problem, if there's money to be made, clever industry folks will figure out a way around that bright line rule. The market and industry will adjust in response to regulation. But I don't think that that's an argument that we should just forego regulation. Rather, it's an argument that we need to think about more nimble forms of regulation, regulation that can be responsive to these changes in industry and the marketplace. And what the Williams decision really shows, and the Williams litigation more broadly shows, is that litigation can play, I think, a limited but important role in making regulation, legislative and statutory regulation, more responsive to commercial changes. So particularly in the low-income marketplace, for businesses that cater primarily to low-income consumers whose problems are not often kind of on the larger public radar, litigation, particularly claims asserting some term is unconscionable, can serve to raise the salience of the problems in that marketplace and can kind of fuel a push for debate and for statutory reform in the political branches. And sometimes, as in the Williams case, that can lead to a new regulatory regime for consumer contracts. So I have spoken enough, and I will now take your questions.
Okay, thank you. And I was going to say we have time for questions. We've got one right off the bat.
Well, thank you for coming to Robson Hall. I have two questions, two-part question here. First question is, Justice Wright got his idea of the doctrine of unconscionability through the UCC. Where did the UCC get the idea from if the doctrine has been dormant for so many centuries? And then my second question is, the doctrine came from the Court of Chancery in the 17th century, which is a court of equity. So in common law, how did it become a part of common law in the US if it's a creature of equity?
Great. So for the kind of backstory of how it got into the UCC, I really relied a lot on some meticulous research that was done by another law professor into the history of the drafting of the UCC. And again, it's a story of kind of happenstance in a way. So he describes a meeting of the drafting committee, and they're kind of searching around for a word to describe. They want a provision that deals with unfair terms, and they're kind of casting around for a word, and somebody says unconscionable, and that makes it in. So, after they seize on that word, then they kind of go back and look at these earlier decisions that talk about unconscionable contracts. And there is a history there that they can draw on, but it really was not based on the gradual development of the doctrine in the courts. It was this particular drafting committee kind of seizing on this as a way to introduce more concerns about procedural and substantive fairness. And then what you also see is they wanted to include other provisions dealing specifically with consumer contracts that were kind of pro-consumer. And the original drafting committee is a lot of academics. And then later on in the process, you get more industry lawyers coming in, and they kind of dial back some of the more pro-consumer elements of the UCC. So there's a great series of articles called Downtown Code and Uptown Act by a law professor named Alan Camp that really tell you everything you would want to know about the UCC drafting history. And then your second question was about equity. How does this get into the common law? So I think the short answer is Skelly Wright, right? So he says in the decision, and when I teach this to my first-year students, right, I say this is an example of courts sort of downplaying the novelty of what they're doing, right? So he says there is this UCC provision. The UCC provision doesn't apply because the UCC was not in effect. However, and he gets some of this from the amicus brief, however, we, as a court for the District of Columbia, have the responsibility for sort of expounding on the common law of the District of Columbia. And we find that unconscionability and the UCC provision is not supplanting the common law, but is sort of reflective of the common law, right? So he says, all along, this was just there, and none of you could see it. But unconscionability is part of the common law. And in fact, what he's doing, I think, is a pretty radical move, but he really downplays the novelty of it and sort of treats this as though it was always part of the common law, even though, as you say, there's not much support for that. It seems like more of an equitable doctrine.
I was just wondering what you think the proper form or mechanism would be for the regulatory regime to sort of mitigate or extinguish predatory lending that's currently going on, if you have any thoughts on that.
So I think, first of all, it's challenging in the US in particular because we do have this divided system of regulation. So my personal view is that we should not take away all power from the states to regulate in this area. But that there's a greater role that the federal government should be playing, and particularly for non-mortgage lending, right? So for payday loans, for rent-to-own, title loans, that the federal government can, and almost did, set kind of a minimum floor of protections, right? And some states can kind of go above that floor and enact more pro-consumer, more restrictive rules for industry, and some states can just sort of rest on the federal floor. But in the US, for example, our Consumer Financial Protection Bureau, which was a very, very new agency, federal agency created in 2010, had proposed a rule under the prior administration, or the prior director, that would have required payday lenders across the United States to determine whether a customer had the ability to repay the loan before extending credit. There was a change in leadership of the agency. The new director of the agency decided to revisit the rule before it ever went into effect, and the sort of direction of the political winds suggests that that rule is never going to go into effect and that they're basically going to gut it. So I think that the federal government should step up. I think this is a tricky space, particularly small dollar loans, because you have to charge more as a percentage of the principal loan amount for lenders to recoup their fixed costs, and to deal with the greater credit risk posed by people who have very low incomes. So I don't think that we can treat little loans like big loans. I don't think the solution is just to regulate them out of existence. But you have to kind of strike a balance between allowing the industry to make money without allowing them to take advantage of the fact that many borrowers really have few other options and are kind of willing to sign on to whatever deal is offered to them. But I think administrative agencies can be much more nimble and responsive than the legislature, for example. And at least in the US, our federal legislature does not get a lot done because there's a lot of deadlock, right? State legislature is a little bit more, but administrative agencies really can rely on experts, can kind of create a more robust data set to figure out what's actually happening, and then can respond more quickly.
Other questions? Yep, okay. It doesn't work for everybody else. It might work for our speaker, but not for the rest of the audience.
I was just wondering if there was any revival or attempt at revival of the doctrine of unconscionability once businesses started getting around regulations like the UCC.
Yeah, so there's a paper that just came out recently on kind of basically suggesting that there has been a revival of unconscionability within the last decade, essentially. And the paper refers to it as, so let me actually take a step back. So it's not that unconscionability has gone away, but a lot of unconscionability claims in the US are asserted to challenge arbitration provisions. And the reason for that is because we have a Federal Arbitration Act, which dates back to the 1920s and was really, I think, directed at a different purpose than the Supreme Court has interpreted it recently. But the Federal Arbitration Act basically says arbitration provisions and contracts are should be treated just like any other contract provision, are fully enforceable. The only basis on which you can challenge an arbitration clause in a contract is any kind of generally applicable contract defense. And the most likely candidate is unconscionability. So there are plenty of unconscionability claims that people assert to try to get out of going to arbitration. So putting those cases aside, someone has recently written a paper that identifies a handful of cases challenging what are essentially high-rate loans, payday loans, other forms of kind of high-cost credit on unconscionability grounds. So one project that I want to take on is to actually look at those cases and try to figure out why are those cases happening now, and are they happening in jurisdictions that don't have good statutory rules, right? So, you know, if you have price caps, right, then you shouldn't have to assert an unconscionability defense to challenge a high-price loan. You should just be able to say this loan is above the rate cap, right? So my hypothesis, which may or may not be correct, is that this burst of unconscionability litigation that this other scholar has identified may be happening in jurisdictions that lack adequate statutory regulation. And so unconscionability is, again, kind of playing this like signaling function. The borrowers are asserting unconscionability to challenge provisions for which there's not a bright line statutory rule. And I'm hoping to look at, to see whether these unconscionability cases have kind of a similar effect on the legislature as the Williams case, right? So when a borrower says, my payday loan is unconscionable, right? I should not have to pay 500% interest. Has that, in the jurisdictions where those cases have been raised, has that had any effect on statutory rules? And I don't know, but based on what I saw occur in the Williams litigation, my hypothesis would be potentially. But you still need interest groups, people on the ground who are willing to kind of take on that cause and try to push the legislature to make some changes.
Wow. I think we're going to wrap up just so that we stay on schedule. But I want, on behalf of all of us, to thank you for giving us the narrative of Oralee Williams and her particular story, and Judge Skelly and that situation, Skelly Wright, sorry, that particular situation. But as you're also hearing a really much bigger or higher level narrative about that conversation or dialogue between legislatures and courts. And what I hear you saying right now is, and the public somehow. Now, how do you get that public voice, that public interest into that conversation? Just, I don't know, a couple of months ago, Chief Justice of the Court of Appeal of Alberta, Catherine Fraser, was talking exactly about that, the dialogue between courts and legislatures and the obligation of courts in Canada to protect the public interest. And so how do you make sure that the public voice is then part of that conversation? And what I'm hearing you say is maybe part of the place is through those administrative and regulatory processes. So you've given us a huge amount to think about at all kinds of levels, cross-border, and for that and for your great talk, I thank you. Please join me.